The issue presented today is whether the federal constitution confers a fundamental right upon homosexuals to engage in sodomy, and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. In August 1982, respondent Hardwick was charged with violating the Georgia statute criminalizing sodomy by committing that act with another adult male in the bedroom of respondent's home. After a preliminary hearing, the district attorney decided not to present the matter to the grand jury unless further evidence developed. Respondent then brought suit in the federal district court challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. The district court granted the defendant's motion to dismiss for failure to state a claim. Then a divided panel of Court of Appeals for the 11th Circuit reversed. It is reasoned that the case calls for some judgment about the limits of the court's role in carrying out its constitutional mandate. The decision in this case is not about whether the court deems homosexuality as morally wrong. Rather, it is about the right of the state to decide for themselves. This majority recognizes Georgia's statute as it relates to the plaintiff constitutional. The dissent believes that this statute violates the 9th and the 14th Amendment and is therefore unconstitutional. However, as we will point out today, the right to privacy provided by these amendments cannot extend to Mr. Hardwick. Although a man has a right to privacy in his own home, that privacy is not absolute. For example, one cannot commit murder, do drugs, or assault another person even if they are in the privacy of their own home. In the same way, Georgia has a constitutional right to interfere with privacy in those cases, they also have a right to interfere with acts the state believes is morally reprehensible and is for the betterment of society. The right of the states is the foundation of America and promotes the democracy of its citizens. Through this, we pursue liberty to its highest possible extent and are able to maintain the beauty of American government and the will of its people. This has been maintained by our judicial system and the restrictions put on the Supreme Court's reach as a governing body. To accept Mr. Hardwick's claim that Georgia's statute is unconstitutional would result in the court violating the restraints put on it to keep America a functioning society. In order to understand our argument, we must first understand the historical context of this topic. First, sodomy laws have been a part of the legal framework in Western societies for centuries, tracking back to English common law. In the United States, these laws existed in nearly all states at the time of the nation's founding and remained enforced in many states at the time of this decision. This long-standing tradition demonstrates that such conduct has not been historically recognized as a protected liberty. Second, the court's role throughout history has not been to create new rights, but to interpret the Constitution in a manner consistent with historical precedent. Expanding substantive due process to include this enumerated right would represent judicial activism and undermine the democratic process.
Okay, to start, the 14th Amendment protects only those rights that are implicit in the concept of ordered liberty. The right claimed in this case does not meet this standard. In addressing this standard, the court must ask, is the right fundamental? If a fundamental right is implicated, does the government have a compelling state interest for interfering? And can the court tailor and actually achieve this goal? Unlike rights related to marriage, as cited in Loving v. Virginia, procreation in Skinner v. Oklahoma, or family in Pierce v. Society of Sisters, which are integral to the structure of society, the conduct at issue in Bowers does not play a similar foundational role. The claim that private sexual conduct should be constitutionally protected lacks the historical and societal significance required to uphold the status of a fundamental right. The court focuses on intent and upholding the law as is. The court properly declined to extend substantive due process protections to consensual homosexual conduct, as doing so would risk undermining the legitimacy of its own precedent by overstepping its authority. Next, the state of Georgia has a legitimate and compelling interest in legislating morality to preserve public order and reflect the value of its citizens. The Georgia statute preserves this order by promoting the sanctity of marriage. At its core, the case is a question of democracy. The judiciary is not a super legislator. It is not empowered to override the will of the people without clear and compelling constitutional justification. Laws reflecting moral judgments are an essential component of the democratic process. The regulation of sexual behavior has been a long-standing right of state governments, and by upholding Georgia's law, the court respects the sovereignty of the state and will of its citizens. Throughout history, anti-sodomy laws have been used to promote the sanctity of marriage. This shows that the statute has direct utility in upholding the tradition, which is recognized as a significant foundation in American history. This is proven through cases such as Griswold v. Connecticut and Loving v. Virginia, in which the court recognized the importance of marriage. While the court has recognized a right to privacy in cases like Griswold v. Connecticut and Roe v. Wade, I believe that it is important to note these precedents are inapplicable to Bowers. Privacy rights have been affirmed in the context of marriage, procreation, and family life, institutions that are deeply rooted in societal and legal traditions. Bowers involves conduct outside these protected spheres and thus does not merit the same constitutional consideration. Expanding privacy rights to include any consensual private conduct could undermine the state's ability to regulate behavior that society deems harmful or immoral, creating a precedent that could challenge the validity of other public moral legislation. To conclude, the case of Bowers v. Hardwick recognizes the historical and legal tradition of regulating sexual behavior and respects the democratic process by deferring to state legislators on moral and social issues. To do otherwise would risk unwarranted judicial activism and the erosion of democratic governance, setting a dangerous precedent for the unchecked extension of constitutional rights. The decision of Bowers v. Hardwick is not about hostility or exclusion. The majority argument presented here is simply based upon the intent behind the Constitution and the proper role that the court plays in this process. It reaffirms that while the judiciary safeguards fundamental liberties, it must also respect the boundaries of its own authority and the wisdom of the people's representatives. Recognizing a new right where none exists in the text, history, or traditions of our nation would be an incredible departure from the judicial restraint that ensures the legitimacy of our legal system.
Awesome. Okay, so going into Blackmun's dissent first, Blackmun's dissent begins by focusing on how the majority misses the main point of the case. Rather than the case being about whether or not homosexual sodomy is a fundamental right, it is about the right to privacy. There's an excessive focus on sexuality, despite Georgia State Law 1662 not distinguishing sex or orientation. Hardwick's claim on the statute involved an unconstitutional intrusion into his privacy, and his right of intimate association does not depend in any way on his sexual orientation. The majority places too much emphasis on the fact that the respondent's Hardwick is homosexual. He acknowledges that Georgia's statute applies to all individuals who engage in the act of sodomy, not only homosexuals.
Blackmun also points out the procedural issues in this case. The court dismissed the case because in the respondent's claim, he invokes the Ninth Amendment, where Hardwick makes a claim that the state interferes with constitutional protected interests in the privacy and freedom of intimate association. However, the court fails to investigate the Eighth Amendment or the Equal Protection Clause, and the court has a duty to investigate all possible avenues, although Blackmun believes that the Ninth Amendment is sufficient for Hardwick's case.
Going into decisional and spatial aspects of the right to privacy are both important to this case. Thornburg v. American College of Obstetricians and Gynecologists states that our cases long have recognized that the Constitution embodies a promise that a certain private sphere of individual liberty will be kept largely beyond the reach of government. The court fails to recognize that a person that has the right to make certain decisions that are concerned with the private interests of the individual. The court also fails to recognize that certain spaces and places entail a right to privacy. This combats the majority's reference to the state's burden to prove compelling interest. The right to privacy is meant to protect the individual, not the general public. So prohibiting homosexual sodomy by not extending fundamental rights is not supported by a traditional claim concerning the general public's opinion and the general public's morality concerning this sexual act. This also aligns with Mill's harm principle on liberty. This action between two consenting adults causes no harm to other individuals.
A way of life that is odd or even erratic, but interferes with no rights or interests of others, is not to be condemned because it is different. This is a reference to Wisconsin v. Yoder. It supports the dissent's case because, like Amish children attending their own school, homosexual sodomy does not interfere with anyone else's interests, or rights. In addition, Blackmun states that the essence of a Fourth Amendment violation is the invasion of his indefensible right of personal security, personal liberty, and private property. In prohibiting the act of homosexual sodomy in the privacy of one's home, Blackmun argues that the majority's ruling violates the Fourth Amendment. Stanley v. Georgia protected the right to keep obscene materials in the privacy of the home, which is no different than sexual acts being protected by the privacy of the home. The right of privacy is inherent in a person's home. Further, he explains that the right of an individual to conduct intimate relationships in the intimacy of his or her own home seems to me to be the heart of the Constitution's protection of privacy.
The right of an individual to choose how to live their life is also important in this dissent. Blackmun begins to explain that the court fails to recognize the fundamental interests of all individuals have in controlling the nature of their intimate associations with others. Moore v. East Cleveland warns against the stating that the right to privacy only applies to the protections of family, when in reality it applies to the protection of all individuals. Blackmun continues to say that we protect the right to privacy not because it contributes in a direct and material way to the general public welfare, but because they form such a central part of an individual's life. So essentially, everyone is entitled to the right to privacy regardless of marriage status or sexual orientation. In addition, Blackmun asserts that sexual intimacy is a sensitive, key relationship of human existence, central to family life, community, welfare, and the development of human personality, stated in Paris Adult Theater versus Slayton.
Next, the petitioner claims to have legitimate interest on behalf of the state, but the dissent believes the petitioner does not have a legitimate interest. Petitioner holds that the general public health and welfare, aka spreading disease, is of legitimate interest of the state. However, Blackman points out that no evidence was provided supporting this point. Petitioner also claimed that Hardwick's sexual activity interferes with Georgia's right of the nation and of the states to maintain a decent society, cited in Paris v. Slayton. However, in O'Connor v. Donaldson, they explained that merely public intolerance or animosity cannot conditionally justify the deprivation of a person's physical liberty, suggesting that homosexual activity, or sodomy in general, does not pose any threat to society, especially when it is done in private. The dissent also sees no justification for the court's attempt to equate the private consensual activity with possession in the home of drugs, firearms, or stolen goods, to which Stanley v. Georgia refused to extend protection to. The majority provides no justification for the correlation between drugs, firearms, and stolen goods to homosexual activity. Blackman concludes that the decision of the court interferes with the individual's right to choose for themselves how to conduct sexual activity. He explains that this judgment is far more threatening to the nation's values of the right to privacy and individual liberty than it is to the intolerance of nonconformity.
Stevens also has a dissent, but we believe it's minuscule in comparison to Blackman's, and for the purpose of our debate, but I'll go over it briefly. Stevens agrees with Blackman that the majority has a fundamental flaw in their argument, being that they target homosexuals when the statute does not distinguish heterosexual or homosexual sodomy. Both are considered immoral by the statute. Stevens also argues along the lines of the Hart-Devlin debate, asserting that Hart's position, just because an act is immoral does not mean it should be prohibited by the law.
Before you guys start, I want to make sure it's actually recording. Just in case.
Okay, who wants to ask a question first?
If you guys want to go first, you go for it.
I can ask. In Blackman's dissent, he acknowledges that the Georgia statute applies to all individuals who engage in the act of sodomy, not only homosexuals. What evidence supports the claim that homosexual sodomy is considered unacceptable conduct? Do you need me to repeat it?
Yeah, repeat it.
So in Blackman's dissent, he acknowledges that the Georgia statute applies to all individuals who engage in the act of sodomy, not only homosexuals. So what evidence from the majority supports the claim that homosexual sodomy is considered unacceptable conduct?
First of all, if all sodomy is considered unacceptable, then all sodomy would include homosexuals. But I think the important here is to realize the intent behind that law. And the intent is to uphold the sanctity of marriage. And recognizing that we can understand why this law is in place and how it pertains to homosexual acts of sodomy. Yeah, we'll just go ahead and ask us a question. Since the right to privacy in regards to homosexual acts is not directly stated in the Constitution or recognized by any precedent of the Supreme Court, what makes this Georgia statute of banning these acts unconstitutional?
Can you repeat the first part? Sorry.
Since the right to privacy in regards to homosexual acts is not directly stated in the Constitution or set by any Supreme Court precedent, what makes the Georgia statute banning these acts unconstitutional?
Do you want me to? Well, as we've learned in class, I feel like the right to privacy, although not explicitly stated, is found in the penumbras of the Constitution. And there are plenty of cases discussing the right to privacy, such as the one with, I believe, Paris v. Slayton, when you keep obscene materials in the home. That is a right to privacy case. So there is precedent supporting right to privacy, and there's nothing that would prohibit extending it to homosexuals, because it is a sexual act, just in the same way that when a married couple performs sexual acts in their home, they have a right to privacy with that. So I think that it is found in the Constitution, it's just not explicitly stated, but I also feel that was intent of the founders, that the Constitution was made to be elastic and to evolve to fit whatever American society it found itself in. So I think it's there, and yeah, that'll help me get there.
Ask a follow-up. So you mentioned the Paris case, as well as the Griswold case. The Griswold case extends its privacy because of marriage, and it understands that, which is a long-standing tradition that's deep-rooted in American society, as well as the other one, which is the right to receive information. They're not committing acts, it's the right to receive information, which also has a long-standing tradition. Whereas homosexuality really has no long-standing tradition. So can you guys point to any type of tradition or way that like America recognizes homosexuality in our history?
So I would not say that there is a tradition that we can point to. However, I would say that Blackman presents a very strong policy argument that very well combats the tradition argument asserted by the majority. I understand the tradition argument. I think that it is a strong tradition argument because it is true that homosexual activity has always been condemned by common law. However, in a policy argument, we're looking towards the future, and in the 1980s, homosexuality was much more widely accepted. And Lawrence v. Texas, that was about, like 8 years after this case, where they overturned this case. So you can see that this American society, although we do not have a long-standing tradition, the tradition is beginning in this time period. So I feel like, even though I do agree with you, there is no long-standing tradition, I feel like the policy argument in this case is stronger.
And also, like, Blackman's dissent is to get away from the fact that it's homosexual based and just more about the protection of individual liberties. And he talks about like the fundamental interest all individuals have in controlling the nature of their own intimate associations with others. And then that's when he talks about Moore v. East Cleveland, because it was a warning against the right to privacy only being in the protection of families and the protections of deep-rooted individuals, when in reality it should be applying to all individuals regardless of if you're homosexual or heterosexual. So that's kind of like the core of his dissent, is that it's not based on tradition and it shouldn't be based about homosexuality. It should be based about individual protections.
I like that you noted, and I think that's valid, that like the time frame of when this case happened and the beginning of a new movement, and I think that is a fair point that you guys brought up. But I just wanted to say that.
Is there any questions?
Yeah, one more for you guys. Do you think that the majority discriminates against individual homosexuals in regards to their rights in the same way that Amish children were discriminated against in Wisconsin v. Yoder?
I don't remember the full extent of Wisconsin v. Yoder, but I don't think that it's necessarily singling out homosexuals in this. I mean, the law broadly states that it covers everybody and it's made to cover everybody. And they're reading it from the intent as is, like as they see it, and they just don't want to differ. They're scared of differing too far from what the Constitution says and becoming illegitimate as a court, which I understand. I think that's a very fair point, that we want to try to stay as the judiciary as legitimate as possible and try to put like moral and societal issues more towards the legislator. And I do think that that's a good point. So I don't think that they're necessarily targeting homosexuals in this, like similar to Wisconsin v. Yoder, but I think they're just trying not to differ too far from what the law actually says.
And to kind of like expand, there's like two key differences in that case and compared to this one. First one is that involves education, and it's not inside the home, which I believe is like the Pledge of Allegiance.
Yes.
Yeah. So as kind of like a public thing, and it's for societal welfare, and it shows like utility. So it's different in that case. It involves a public sphere of education. This one, and the second one, and definitely being the biggest, is that involves the long-standing tradition of religion. I mean, America is founded on religion and the freedom to believe what you want to believe. And we, of course, believe that tradition is stronger than the policy argument, and believe that is where that key difference lies. And to kind of continue with the policy, in light of the court's role, this is a question for you guys. In light of the court's role in interpreting the Constitution rather than creating new rights, how does this dissent justify its approach without engaging in judicial activism?
Do you want to take?
Yeah, I mean, I think that judicial activism is like definitely a point to be made when you're making tradition arguments, that this has, not been a common issue, and because it's deep-rooted in tradition and American values of marriage between a man and a woman. But I would like to say that he focuses more on, I'm finding this specific case, how it doesn't like pose a threat to society, but I think that it has to be a level of judicial activism in this dissent, just because this is something that is out of tradition. So I mean, it's just gonna be a big aspect of his dissent, but he was counteracting that it focuses too much on homosexuality and not on the right to privacy.
Kind of to jump in, I I feel like there probably is an element of judicial activism, but when I view this case, it seems as if Blackman is also implying that this individual's rights were always there. Just because again, 1662, or the statute against sodomy, it doesn't distinguish orientation or marriage status. So with that being said, it means that technically this individual is considered no less than a married individual. So therefore, inherently, he has the same rights as anybody else. So I feel like, yes, there's an element of judicial activism, but in the same way, his rights were already there, and Blackman's trying to uphold his rights of
He also,
privacy.
to jump in, he approaches it as a procedural issue as well, because the court failed to investigate the 8th Amendment or the Equal Protection Clause, and they didn't fully investigate all possible avenues, and that's like another big key part of his dissent that's really not even relevant to the homosexual aspect of it whatsoever, the judicial activism. And he just believes it's more about his, like how she was saying, like the fundamental rights that he's already guaranteed as an American citizen.
I guess the question is, how do we determine a fundamental right? And I believe in America, states have the right to of course there's a nationwide broadness of like the right, and that's substantiated in tradition, and that's how we measure what is a natural right. But I believe an even more so natural right is the state's right to kind of continue their beliefs of what immorality is. And so when you guys talk about participating in judicial activism, why not just leave it to the states to make their own decision and uphold that tradition of states being their own, creating their own liberty in a sense, having their own rights?
So, to pull from Devlin, because I feel like that kind of follows his line of thought. When you preserve a certain sphere of morality, you fall into the case where the court always falls back on that without considering other arguments. For example, in this argument, because it is 1986, and we have to consider that times have changed, and I feel like that is a responsibility of the court to notice when society has changed. Although I do think that I do give a lot of merit. The court does need to protect itself and legitimize it. So departing from long-standing tradition is a scary thing. Although I think that Blackman makes a really good point that we have to consider the nation's value of a right to privacy and individual liberty. And I'm mainly focusing on individual liberty here because that is what is crucial to being an American citizen, rather than falling back on the state's moral code. While it is important, I feel like the moral code in this instance, it's if there's an individual in the state committing acts like this, and also I believe they said that normally these acts aren't necessarily prosecuted in like strict forms. So I feel like they kind of have to take notice of the fact that their citizens are changing as well. So they're not protecting all of their citizens' individual liberties and rights in that sense. And I don't know if I answered your question fully because I kind of got off track.
No, I'm sure you got in there somewhere. Do you guys have any more questions for us?
We have 2 questions for the class.
Do you want me to ask mine first?
Yeah, you can go first.
In your opinion, is the traditional argument presented by the majority stronger than the policy argument presented in Blackman's debate, or dissent, sorry?
I say no, just because like tradition is, while it is enshrined in like our politics and our culture and stuff like that, it's not as rigid as policy can be. And you see tradition changing over time with, you know, like different things impact tradition. What's traditional now may not have been tradition 30 years ago, you know? But policy, I think, has, well, both have a big impact. I think it's more applicable to this case. Like with Bowers v. Hardwick, I think that's the courts trying to lead the people. It doesn't work that way. You can't use tradition to try and force people to bend to your will. I think during this time of Bowers v. Hardwick, people were already starting to become more comfortable with the idea of homosexuality. And yeah, I think policy is probably more relevant than tradition, but tradition is what the majority definitely used for argument.
So on the other side of that, you say that like it's court's way of leading the people.
Right.
I feel like when they participate in like that is the kind of like the status quo in America at that time.
Mhm.
So I wouldn't say they're leading the people more than already representing what has been the way for like a long time. I think if they were to step in and overstep the states, then they would be leading the people, which is just like way out of the court's kind of restrictions. But I do understand like how it could be seen as like leading the people, and then that's definitely like up for interpretation a little bit.
The one thing is like, I do kind of feel like the tradition argument is strong, just because, like they said, it's the tradition argument plus the legislation versus judicial activism argument, and I think those two combined kind of feel more strong to me than the policy argument, which is kind of, to me, feels a little bit isolated. And that's because I think they're not saying tradition makes this perfectly okay, but I think they're saying, as a judge, I'm just trying to see if the Georgia statute, if the Georgia statute is good enough to where we shouldn't overturn it. And I think they're trying to keep state interest while also doing their job to say, well, is this like, did the legislation just drop the ball here? And I think they defended the fact well enough that, yeah, it's kind of not defended by tradition. Yeah, we kind of want to support marriage, and sodomy laws have been around. This law doesn't seem out of place in America. And whether it's good or bad, I don't think that's where the judges should intervene. Like, I agree that it's the legislation's problem. And I think they did get, the tradition, defended the fact that that law's good enough not to be overturned in this case. But you guys do make an interesting point when you said this is the start of a new tradition, which is, and then it gets difficult. It's like, how do we start new traditions if, you still want to keep the old ones?
That kind of brings up the Devlin Hart debate with the fact that Devlin believes you need to preserve whatever morality has kept, because like you guys are right, the tradition has kept Georgia stable for the time being up until this point. There's no reason to necessarily change it. Don't fix what isn't broke. But when you have a policy like that in place, or like not a policy, but a way of doing things like that in place, you prevent any advancement of the court. And I feel like for issues that are controversial, like homosexuality in 1986, the court is a faster way to make progress, even if it is a little bit of judicial activism. But a sphere of morality can't be kept. It can't be kept in a bubble. It has to be open to moving with the people rather than always siding with the majority. And that kind of leads into my next question for the class. You guys are up for it. Do either of the dissents seem to align themselves with Hart's assertion that the law should not be enforced based on public morality, meaning that the tyranny of the majority should not prevail? And that kind of goes back to what I was just saying. You can't have the majority always take precedent. I feel like that kind of undermines democracy, because you're not listening to the other side. And in this case, Hardwick serves as the other side, I suppose. So, yeah.
That's a good question.
Can you give me like
I can repeat
a
it.
brief overview of like what both dissents were?
So I mean, they're essentially, again, Stevens, he agrees with Blackman. So Blackman is essentially saying that an individual has the right to choose how to conduct their sexual activity, and that's, in his opinion, under the right to privacy. That's why Hardwick invoked the 9th Amendment. He also, at the end of his dissent, he makes the point that this decision kind of threatens the right to privacy and individual liberty over preserving tradition and morality. Like, as he admits that is important, but he thinks that the right to privacy and individual liberty are more important.
He believes like the majority focused way too much on homosexuality to begin with.
Yeah.
That it's more about the right to privacy than anything.
Yeah, he kind of slams the majority for focusing too much on homosexuals when the statute doesn't distinguish between orientation. That is another big problem for him. He thinks that the court kind of missed the point. And then Stevens,
he just agrees.
Yeah, he agrees, and he just wanted to make his own dissent and be special.
Yeah.
Yeah, I was saying it doesn't really have anything.
What do you
Yeah.
say? What do you say?
No, we were actually struggling with that for like the longest time of like how if it doesn't specifically state homosexuals, because even in like if we listen to the oral argument,
gotcha.
and so the Supreme Court asks, I think Bowers, they're like, so if this pertained to marriage, would it be unconstitutional? He's like, yeah. I'm like, wait, it kind of does a little bit, but then I guess like our argument was like, if you guys were to ask, I would just been like, well, the intent of it was supposed to be towards homosexuals and not necessarily marriage
Right.
people, you know?
Well, and I feel like that's kind of also a problem, because like you protect the right of married individuals, because who knows what goes on between husband and wife. They could be doing the same thing that Hardwick was.
Mm-hmm.
So by punishing Hardwick and not punishing married couples who engage in the same activity, you are distinguishing him as not only as a homosexual, but as someone who basically the court is saying that they don't have the same rights as married individuals. So I also feel like that's kind of another really big point of Blackman's dissent.
Mm-hmm.
He doesn't want anyone to be treated differently. Like, it doesn't matter if you're married, gay, lesbian, whatever, like you are all people under the Georgia statute. And the Georgia statute, now I feel like if the Georgia statute was against homosexual sodomy, I feel like tradition argument would be a lot stronger, because it distinguishes a certain class of people. But it doesn't do that in this case. So I feel like that's mainly where Blackman is coming from.
So do you think like the strongest argument for the dissent is more like a focus on individual liberty and like equal protection? Do you think
Yeah.
like that's the strongest
Yes.
argument?
I would say so, and all the court cases he references, and there's like so many of them when we were going through this.
Like,
I
It's
know.
all
Oh my
just-
gosh. I was
It's
so
all
sorry.
him just setting. It's all setting the precedent of that people have the right to privacy, especially in their own home. Like each court case kind of distinguishes that, and I appreciate that. Like I think his policy argument is strong, because I really think that's the only thing that would be able to properly dissent such a strong traditional
One
argument.
thing-
But
Yeah, I mean that was a good argument, but like the one thing that like, I like I said, I swept it under the rug, but the 8th Amendment one where it's about the cruel and unusual punishment, they're like, because you guys didn't talk about it, we don't talk about it, but then you guys could have read that little citation that says the court has to uphold anything that might say it's unconstitutional, you know, in regards to the 8th Amendment, because apparently like this, like the 8th, I think it was Blackwell that said the 8th Amendment makes this unconstitutional because charging somebody with sodomy for the same as somebody who makes like that like armed robbery is like the same thing. It's like unusual and cruel.
yes, yeah.
And that's like an 8th Amendment. But since he didn't talk about it, the court didn't look at it. I thought you guys were gonna come at us for that.
Yeah, I mentioned briefly, like, the court doesn't, that was like part of his like procedural claim, in his dissent, that like the court didn't investigate the 8th or equal protection clause.
Yeah.
And that they didn't investigate all avenues, but he agreed that the 9th Amendment was sufficient for the case, but he does mention that it wasn't
Yeah.
looked at enough, so yeah, I definitely should have been something that like was brought up in the actual like situation, but.
I got one last question for the class, for you guys. What are the broader implications of recognizing a constitutional right to engage in same-sex sodomy for other laws regulating sexual conduct, such as those addressing adultery, prostitution, or age of consent?
Well, I mean, there are protections for like age of consent and stuff like that, you know, because it's a minor and all that. But when you take into like sodomy, adultery, you know, all that stuff, there's no real laws for adultery, right? Like, you can do that. You can just do that without having to.
It's more of like a morality thing.
So if it's more of a morality thing, then like it's harder to police and, you know, put guidelines on and stuff like that, because morality is more fluid and it's going to change with time.
What about like something like prostitution?
Yeah, prostitution.
So I feel like one way to distinguish these various like actions, you have rape, murder, not murder, but rape. If you're considering sexual immorality, rape does cause harm to another individual. Adultery, I would argue, could be prosecuted on like the pain and suffering of like either a wife or a husband or whatever. So in those cases, harm is caused to another individual. But when you have consensual creating new words today. But when you have like consensual sodomy between two adult males, both consenting, no harm is caused to anybody else.
Even
So
in something like prostitution?
Prostitution is an interesting one. It's a very gray area. It's done on the streets. Some women are literally, they work for escort services, and it is considered prostitution, but they make good money, and they are not technically causing harm to themselves because that's their profession. Now, then there are other situations where women are exploited.
Consensual.
Where it's unconsensual, where they're under the power of, what is it called, a pimp or whatever.
Under the power of
So I feel like prostitution gets kind of messy. But when you're dealing with, but if you compare like sodomy and rape or sodomy and adultery, and even adultery gets iffy because that's whatever. But to consider rape and sodomy, I feel like the difference is the harm that is caused. So you can't, I just feel like they have to be treated differently. Because you have to consider what a crime actually is, and that's also up for debate because you could argue that it harms society to allow immoral acts, but you also have to consider the individual as well. So what do you favor more for society? Like, and can you, and again, I'm pulling a lot from Devil and Hart because it's on my mind because I did those reading questions last night. But like, how do you compare treason with just immoral acts in society? What is actually more threatening to a society?
Yeah, and it's also, well, that thing is like you can talk about like the anti-paternalism, you know, and like how like it's harm to others, like that's what constitutes it. But then you also talk about one could say like, well, drugs, that's kind of like a paternalistic measure.
Yes.
But then you can kind of say, well, it's harm to oneself, and so like, does consent have with another gay man cause harm?
Well,
It's weird.
I have a question for you, just based on that. Do we compare drugs and firearms? Are they equated equally to sexual acts? Do we want to make that the precedent as well, that they should be treated the same? Because I feel like they're kind of different.
I don't think.
I think they're incredibly different.
Yeah, for sure.
I think with the adultery and prostitution, the answer for that is literally it depends, because somebody could take it as like, this is a living for me, I'm making really good money and I'm happy doing it. But somebody else could take it as like, this is awful, I don't want to do this, I'm kind of being forced into doing this. And then it's a completely different scenario.
Yes.
Like, it's not the same thing at all between those two things. That's why I think that the answer is probably it depends for both of those. Same with adultery. Somebody is being harmed, whether that's physical or not. They're still like suffering emotional and like damages from it. So I think it depends on the person, really. And that's why it's so hard.
Like, what went down between the couple to cause adultery? And I also feel like it's different today because like back
it's much
centuries
different
ago,
today.
when because women they relied on the man, so if the man did cheat on her, it was kind of like,
it's a different effect.
it's like, I have no other way. But today women can work, we can take care of ourselves, so it's kind of like, are we really gonna sue because my boyfriend cheated on me? No. Like that's too much.
If I had
Starting
to,
a new tradition.
if I had to argue against like the prostitution thing and be like, draw the difference, I'd pretty much just say that, that's pretty insanitary. And I as a legislative person for Georgia, I do not want a bunch of, sex getting spread and whatever. And I think that's kind of like the argument I would go about it. But no, that one is like kind of hard. And there's probably something about like the economical, ethics of it.
That's funny because it's mentioned in like the petitioner holds up the general public and welfare, aka like spreading disease, is legitimate interest of the state, like how you're just saying. But Blackman said that there was like no evidence actually supporting that other than like the claim that it's
that's why you
disease.
can say. Well, homosexual doesn't really cause as much disease as something like prostitution.
Yes, class.
Yes. So you're talking about prostitution. It kind of reminded me of Paris Adult Theater v. Slayton, in that it's regulating the commercialization of sex, right? So Paris Adult Theater, they're showing these adult movies, and the state has a right to regulate what movies get shown. Just like a state has a right to regulate if you're giving sex in exchange for money. you're commercializing that sex. So the state has a right to, you know, regulate that. But with adultery as well, it can be used as legal things. I mean, think about people who get divorced because of adultery, or have in their, like, what is it, prenups, that if an adulterous act is committed, then you
It
don't
grounds
get
for
this.
divorce.
Yeah, it's grounds
Well,
for divorce. So.
That's kind of like a catch-22 a little bit, because if you're gonna sit here and say like, well, the state has a right to stop these movies because we have a state interest in keeping society a certain way, then you could just extend it. Well, if you believe that, then you have to believe, you know, homosexual acts. Also, I have a right to stop liberty there because I want my society to be a certain way, you know? And then, like, oh, well, yes, privacy of individuals, but what if I, like, show those movies in my home and invite a bunch of people over and, like, you know, maybe charge a little bit on the side? It kind of gets
Well,
twisted.
there's no, there's nothing prohibiting watching obscene material in the home. Which case was that? Because I think it wasn't
Stanley v. Georgia.
Yeah, in Stanley v. Georgia, they end up deciding that they're gonna regulate obscene material in public, but in the
Mhm.
privacy of the home, they're like, cool, do what you want
Yeah.
to do. So I feel like there is a case to be made against that in terms of precedent.
Yeah, I mean, there definitely is. I was just pointing out, like, how there is, like, a scary,
Yeah.
yeah, it's a fine line. You.
So the way I like kind of am seeing this case after hearing both sides is like the part for me that is like bothering me is like I agree that there's more good from allowing, you know, the sodomy being allowed inside the home. I believe it does protect individuals' liberty. But one thing, I didn't even think about like the context after the case. Like, well, if this were to be overturned, which it eventually did, it does kind of open the gate to the judiciary having the power to overturn in some way laws made by the states. And I believe like if we're going to restrict sexual acts, I believe there's a lot of things that the state is kind of iffy on. Because like if you want to use the harm principle, there's like, I don't want to get into graphic details, but I'm sure there's harm that could be caused from two married couples performing some things in the bedroom. And I don't want to get too graphic, but maybe even something like, I don't know, like defiling of like maybe a corpse or something like that. That doesn't seem to provide harm to the corpse, or maybe, I mean, obviously like
That's a good example though.
but the sanctity of the dead might be the tradition there.
Yeah.
And so like, but there's like, so there's ways, and maybe it doesn't harm, but what about the sanctity of the dead? And then in this case, like, oh, there's no harm to, you know, the homosexuals performing the act, but then again, like, we want to promote marriage, and maybe sodomy's not something as a culture we want, and it all seems very difficult. And so, and I agree with the difficult and the tension. My problem is the judiciary kind of coming in and saying, oh, well, this is bad, because I don't know, it differs from state to state. It's hard. Like, I don't.
Yeah, no, I totally agree, and I really think there's no way to refute it, and I think, you know, that's the end of that. I'm kidding.
That is difficult, and I'm a firm believer that like every case is very circumstantial.
Sure.
So I feel like when we consider cases involving sexual immorality, sexual acts, the court has a very big responsibility to figure out the context of what was going on, and that's another reason why I feel like this case is very interesting, because Hardwick wasn't a bad person in society. He was just a normal guy. I didn't read anything that said that he was like, I don't know, like causing a nuisance in society. He was just doing what he was doing in his home. Now, if you're protecting sexual acts in the home and you have a husband and wife who are abusive to each other in the bedroom, and one of them comes to court and is like, this is not okay, I feel like that's kind of where you're like, okay, we kind of have to breach privacy, because there's potential that two people are being harmed in a toxic situation or something like that. So I feel like the court kind of forgets that they have to be very specific and consider context, and we get into these arguments over very like broad statements, and it's like, you have to remember each case is different. And I feel like when a lot of people write about the sexual morality and sexual acts and anything along these lines, they kind of forget about that, because I feel like they're different from, like, even obscene material when you're considering sexual acts of human beings. It is a very, like, intimate thing, and and especially in 2024, we know that who knows what people are doing today. It could be a number of things. So you have to really get down to the nitty gritty of facts to figure out, okay, is this worth prosecution or is it not worth prosecution? Is there legitimate interest of the state? Is there harm being done? There should be like a list of things to be considered when it comes to cases like that, but that's just my brain.
Yeah, I mean, that's just like the entire point of the Supreme Court is to kind of like look at these instances as they come. If I was Supreme Court and I looked at somebody having sex with a dead body, I'd probably just say, you know, they couldn't consent, you know, so the idea of two consenting adults doesn't apply.
But is it an adult, is it not just like flesh
I also
or meat? Like,
okay, I
well,
also
what- I'm just
People
saying.
can
like-
consent
There's
before they
post-human-
die.
can't we?
That's
That's
different.
tricky. I mean,
But like, is it still a human? After
yeah, it's
somebody's
still human.
Oh, see that's crazy.
Because we respect the dead tradition.
But I feel like as a society we can all agree that necrophilia is wrong.
Yeah,
Whereas-
just
Necrophilia,
But that's the point. That's my point. Is that as a society, I'm sure everyone thought gay sex was
There's a
wrong
lot
at
of
some
people,
point.
especially
Who knows?
in
Like
Georgia.
I'm never gonna be the dude to be like, low key, we should. You know what I mean? Like I'm never gonna be that guy. But who knows? Maybe some dude in 20 years from now will be like, what?
No, I
feel like
definitely.
that's a great note.
Yep.
All right, good job, guys.
Thank you. Round of applause.
Thank you,
Should we
guys.
press the draw?